Everybody say, ah. Say, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. You're my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Who am I thinking now? Who am I thinking now? Who am I thinking now? Oh, who am I thinking now? Yeah, so who am I thinking now? Who am I thinking now? Yeah, who am I thinking now? Oh, who am I thinking now? Say, I call you Jireh, say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. Yeah. I can breathe without you, say. I can breathe without you. I can move without you, Lord. I can move without you. Hey, who am I without you? Who am I without you? Say, I can live without you, yeah. I can live without you. I can breathe without you, Lord. I can breathe without you. I can move without you, yeah. I can move without you. Who am I? Who am I? Who am I? Who am I? Hey, who am I thinking now?
Hello, lovely people and wonderful friends and family. We're back again with you on the community and the law. And tonight, this afternoon, this morning, wherever you find yourself, we're going to look at how to successfully make an administrative review application for a visa refusal. And we're going to do that under the auspices of BWF Solicitors, our trusted partners when it comes to the law. And of course, we're having Lawyer Charles Asma with us to help us through how to do that. It's a community and the law, and is brought to you by BWF Solicitors Live. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law It's brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, the community, and the law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's the community and the law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, and I know you're so ready to go with us, and we are so very ready to come along with you. It's a Saturday afternoon in February here in the UK, and we're bringing you the community and the law, brought to you by BWF Solicitors. My name is Oreku Frimpon, and I have the honor and the privilege to be hosting this 2-hour session where we'll be talking law, we'll be talking immigration, we'll be talking updates, and we'll be talking customer satisfaction. And we'll be talking BWF solicitors as well. This afternoon, we are going to lead you into a discussion as to how you can successfully make an application and also go on to do an administrative review. What happens when we say you go to do an administrative review? uh, why do we even have to go to that situation at all in the first place? Then, apart from that, making an application for or making an administration review application for a visa refusal is done in a certain particular way. And there's a very successful way of doing that. You may not know, I may not know, but the lawyers do know. And particularly from the stables of BWF solicitors, we have somebody who will tell us how to do it and how to do it successfully. And that is our resource person and guest this afternoon, lawyer Charles Asma. Lawyer Charles Asma, good afternoon, and thank you for joining us. How are you doing?
Very well, thank you, Bragoku. How are you too?
Well, I'm fine. You know what's exciting me this afternoon? We're still in February, but I could see the sun out, and we got into double figures as regards the temperature. So I'm excited, really.
I am excited as well. It's refreshing to feel that it's getting better in terms of the weather.
Right. Well, thank you, and we're so privileged and happy to have you with us. So, viewers, just sit back and relax because we're going to have a very exciting discussion this afternoon. But first of all, let me go on to, as I mentioned earlier, on customer satisfaction. And our clients, our friends, and people who patronize the services of BWF solicitors are talking. I'd like to thank Lawyer Charles Asma for his attentiveness and making this process very smooth, and we'll definitely recommend him. Miss Mensah says so. Lawyer Asma, this one comes directly to you. Miss Mensah is very happy with you.
So this is one of our numerous happy customers. What we do is to support, encourage, and empower. And this is one of the things. So it goes to show that if you knock on our doors at BWF Solicitors, we use the law to assist you regardless of your situation. We'll let you know your chances and work with you to maximize that chance. So thank you, Miss Mensah.
Well, Miss Mensah and people like you who are satisfied with BWF Solicitors, what I'll ask you to do, visit the website of BWF Solicitors, that's www.bwfsolicitors.com, and leave your reviews there, or go to Google, search for BWF Solicitors, and leave your comments there. You can send them to us here on our text number 07399208468 on WhatsApp as well, and we'll let the lawyers know you are happy with what they are doing. And if you have any feedback to give them as well, we will encourage you to do same. When the lines are open, you can call in on 0208 493 7345 or send a text to 07399 208 WhatsApp, same number, 07399 208 Well, there are various happy clients, happy customers, happy people, happy members of the family who have joined us now. We are live on BWF Solicitors on Facebook, BWF Solicitors on YouTube, and BWTV, both on Facebook and YouTube, and of course on all the social media platforms as well. So let's see who's here, and let's say welcome to them. So we shall start the journey and move along together. When you come in, you share the page, like the page, and of course announce your presence in the comment section down below so that we can see and also welcome all of you. I know several people are getting ready to go into that discussion, and remember, we're going to have a lot to learn this afternoon. So let's see who's here. Well, Tilly, obviously, I understand you are the first. Oh, yes. Tilly, I understand you are the very first person to come in. Thank you very much, Tilly. God bless you. And you're saying hello to everybody. Hello to you as well. Thank you. Tilly, as she does quite frankly and very fervently calls on people to come in. And Margaret, she's calling you. And we have all the others coming in. Abna Obenewa Santewa Papebi, you are being called, and I know you've joined us. Thank you very much for coming. Paul, Tilly is calling, so please come on. Umpini Adam, how are you? Where are you? Penelope Pinzo. You are also being called Bobasari. Uh, Tell me, where do you get all those names from? Abigail is there. And she says, kindly share, comment, and like. Thank you 3 times. We love you and want to have you come with us. Okay, now having welcomed people, let's see what we're giving as part of our updates and things that would encourage us to be more confident and also have a lot on the tip of our fingers. Do you know that if you enter the UK without permission, you may not qualify for British citizenship? Good character requirement made or updated on the 13th of February 2025 says that a person who is not a British citizen may not enter the UK unless given leave to do so. The new caseworker guidance for British nationality now says that from the 10th of February 2025, those who entered the UK illegally would not usually qualify for British citizenship. Now, those of you who were with us on the program last week, we had a lengthier discussion on this and it's been reiterated. But there's something here that I want to put to lawyer to help us clarify. Now, it says those who entered the UK illegally would not usually qualify for British citizenship. It looks a bit different, maybe from my perspective, a bit different from what it was said earlier on, or is the same except that is a semantic thing.
So is it the word may?
Hello?
Are you looking at how it is couched? The use of the word may.
Yes, that's what is kind of because you lawyers, your jargons, each one of them has a connotation. So if it says may, it probably may not mean definitely, or there may be a condition attached to that. That's why I'm looking at looking out for some clarification, so to speak.
Okay, right, yeah. So it says would not usually qualify.
Mm-hmm,
And if somebody says that you would not qualify, that means it's a conditional phraseology.
mm-hmm,
So if this is put it this way, then it's more of a discretionary approach. Even though it's clearer that if you enter the UK illegally, you will not qualify. It says you would usually. So the operative word is usually.
mm-hmm.
So that means it may be possible that you may have an unusual consideration.
Okay.
Unusual consideration because usually you don't. But you may unusually, who knows? And therefore, it's always important that when you are setting out to apply for these things, you set your case out such that they may consider you beyond the usual spectrum. But it's
Okay.
clearer that the caseworker has a discretion, and it's a high discretion per se. But it's again a case of whether the way you set it out, the caseworker may be able to apply that discretion in your favor or exercise that discretion in your favor or not.
Well, so yeah, it's clear from the 10th of February 2025. If you enter the UK illegally, you would not usually qualify for British citizenship. No, there's a question here. I think probably last week we did touch on that, but it's come back again, and I find it on our text message equipment, and it's asking that if I came in though legally under a different identity, and for some reason my identity, my name has kind of changed. For instance, this is my extension to it. It could be that the person has signed a name deed, or the person is married and taking up the spouse's surname and all the rest of it. If the person has evidence of entry, and at this point in time, the identity or the name may have changed, would that qualify to be an illegal entry at that time?
So we have to determine whether the person is or the person could be um, considered to have had double identity. You know,
Okay.
double identity is in itself an offense.
Mm-hmm.
If we establish that there's no double identity here, then we are looking at change in name. Change in name. So if your name has changed
Mm-hmm.
since you entered the UK, that's not an offense.
Okay.
So you entered as John Bento. In the course of the stay in the UK, you change your name to Philip Bentleton. It's the same person who has changed the name. We just want to establish that, yes, you changed your name, and so you have your name deed.
Mm-hmm.
This is you entering the UK, and you have your evidence that you entered the UK legally through the entry clearance ports. Then you are fine. I don't see why anybody will say that it's an illegal entry just because you have changed your name in the
Mm-hmm.
course of the period.
Okay. All right. Well, I would say that if you have any further questions, you're not clear about anything, BWF solicitors, their doors are open. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. You can call them on 0208 493 7340. Book an appointment to speak to any of lawyers, and also give these things for them to handle for you, because sometimes it's quite technical and you may have some difficulty just maneuvering around it. So I would recommend that you give all these things to BWF solicitors for them to answer for you. And if you have any question, you can call the emergency number 077 127 61884, or you can call lawyer Charles Asma again on 07947636036 and 37, sorry, 636037, and he will help you answer these things. So yes, that's our nugget for the day. And let me see if I can test your knowledge of that. So let me give you a scenario and you think about that. I'll come back at the end of the program to find out if you were able to give me a correct answer. Kwesi Tim came to the UK through Dover without a visa. He says he traveled by car and was not asked any questions by the immigration officers. He acquires indefinite leave to remain in 2023 after 20 years. He has heard that because of a new law, he cannot apply for British nationality, although his wife and 3 children are all British citizens. I want you to explain to Kwesi whether he is likely to face any legal challenges based on the information we had last week and earlier this afternoon. Explain to Kwesi whether he is likely to face any legal challenges. Would it be one, or would you tell Kwesi, no, you will not qualify for British citizenship because you entered the UK illegally? Would you tell him or explain to him that he will qualify because he got his indefinite leave before the new law? Or 3, would you say to him that he will not qualify because he needed indefinite leave for 5 years? So think about it clearly, carefully, and when we come back, we'll look at it again. I'll bring it back later on, but in the meantime, let's go and take a quick break. Then we'll come back to have our discussion. What we're discussing this afternoon is how to successfully make an administrative review application for a visa refusal. Let us as our guest and resource person, and we are coming your way courtesy BWF Solicitors. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for still joining us. Is the Community on the Law, and is brought to you by BWF Solicitors. Our resource person and guest this afternoon is Lawyer Charles Asma. Lawyer Charles Asma, just before we're going off for the break, there was this thought of some pointers as to what illegal entry would be. Would you be kind enough to let us in on that?
Sure. Yes. So we're looking at illegal entry. Some may wonder whether it applies to people who have entered the UK and have overstayed or are illegal at the moment. If you enter the UK, like the person who sent the question about coming in with a name and changing the name later, if you enter the UK with a visa, you are legal entrant. If the government, through international or bilateral arrangement and humanitarian protection, brought you into the UK because there is danger where you were living, that is legal entry. And so we are looking at entering the UK by deed or by clearance. By clearance means that you have gone through the visa acquisition process, you've got the visa, you've entered the airport. In other words, you've arrived at the airport and the immigration officer has cleared you and you've been given entry clearance. You are in the UK. You entered legally. By deed, is where the government, by its own deed, has given you permission to enter the UK, even though you were not given a visa per se, but you were brought in. So arrangement in place. For example, in Ukraine, there had been the need for the government to let people enter the UK for humanitarian protection purposes. Such people have entered legally because the government made it so for them.
Mhm.
And so many other aspects. In Iraq, and so many other countries, when there were issues, government allowed some citizens of such countries to enter the UK with a view to seek humanitarian protection. That is legal entry.
Okay.
But if you didn't go through that arrangement, either yourself or through the government or by operation of law, for example, you were living in Ireland and you entered the UK. If you entered Ireland, Ireland and Great Britain, have some bilateral arrangement in terms of immigration arrangement for people. And so if you're living you entered Ireland legally, and you found yourself later on in the UK, even if you came by coach or whatever it is, because you entered Ireland Ireland and Britain appear to be akin to each other. And so once you enter there legally, if you are now living here, it's as good as moving from London to Manchester or from any other place to another town within the UK. So those are the three key arrangements. One, getting your own visa to enter the UK. Two, the government bringing you to enter the UK because of war and humanitarian issues. And three, entering through Ireland because at the time you entered Ireland, you had legal entry. And so UK and Ireland, that's Republic of Ireland, have bilateral arrangement for immigration purposes. And so you'll be construed as entering the UK legally as well. So if you went through these three options, you have legal entry. If you didn't, then of course you didn't enter legally. Example, and in the scenario we had, we are told that the subject matter says that he entered the UK in a car. He wasn't questioned at the port of entry when he entered the UK, either through Dover or through wherever the person has entered. Some people also enter by boat. Some people enter by so many other means, but they are not cleared, and therefore such processes appear to be improper. And if it is not improper, we say it is illegal entry. So those are the differences. Now, if you've entered legally and you are living in the UK, this change of law does not apply to you.
Well, one way or the other, a lawyer has kind of answered my question. But yeah, I'll still get you to keep thinking about that and get me the answer at the end of the whole thing. So let's now get ready and go into our discussion. Um, I have a couple of people who have joined us apart from Tilly Duma and the people she mentioned, Ade Taribo, Ekuyasafo, Abibiu. We have Fred Amoa, Protocol Kwame Safo. You're also watching with us. You say good evening. Nice to join the program. And every bless you. Jima Boache, greetings to you. A special one to you as well. Gerald Agbert, you've joined us. Vera Minta, Hajman, Haj, Man United, you're watching. Okay. Well, Abner Tivo, thank you very much. You say good evening to everybody. Well, good evening to you as well. We have Abdul Wahab, Kwame Boabing, Lyrical Black, Chikpa David, Esther AJ, and a host of other people. So I would want to urge you that if you join us, just announce yourself. Let us see that you are there, and we will definitely acknowledge your presence and welcome you to the discussion. Lasma, we're talking about administrative review. And from the topic and the subject title, we assume that an application has been made and then there's a refusal. And when there's a refusal, the person will want to ask them to look at the situation again and grant it. In sum, am I right?
Yes, that is the point. And so that brings us to the end of the whole discussion.
No, don't go yet. Don't go yet because we still have questions.
But it's good. It's good that we give people opportunity to seek clarifications on the basis of the point that you have rightly made. And so we'll go through a second part of the conversation to give people opportunity for clarification.
Okay. Now, if we say administrative review, um, you tell us that there's an appeal. Well, somebody refuses you something you have put in, and you don't agree. You think that the person didn't do you well, and you want to appeal. Would that not be the general and the normal thing that will happen? Why do we have to go through administrative review? What does that mean?
Thank you very much. We're going to take this practically and simply for the benefit of those who are following us without any knowledge of law. And we are bearing in mind that we are dealing with ordinary viewers and listeners with general understanding. So I'll keep it simple in that front. So I'm going to go through an analogy. So you, Brakweku, my host, what you say is that anytime we come on the show, Community and the Law, every Saturday, you will give people opportunity to understand the nuggets, and you ask them to prepare so that when it is question time, they can answer the question.
Yeah.
Now, on a particular occasion, you come in and for whatever reason, you didn't give that opportunity and you give them the questions to answer. For those who will get it wrong, will they question you for doing something wrong, which might have made them not succeed in their answers?
Yeah, definitely, because the norm is that I'll give you the scenario, think through it, and give me the answer. So if I don't give the scenario for you to base your answer on, then I would have not dealt with you fairly.
So let's assume that those people, and producer, if you can put us side by side so that we can have interactive engagement. So let's assume those people who get it right are
Hmm.
given are given benefit of their success, so they get a prize.
Hmm.
If you miss that chance to give them the preview or overview, and as a result of that they got it wrong, and as a result of that they missed the opportunity to get that award or reward, can they say that because you failed to follow your own practice, you have caused them that failure?
Yes, they can, because I would have set the precedent that to be able to answer, follow these questions or follow this scenario I've given you, and based on that, you can give me an answer. But then I hide that scenario from you, and I expect you to give me a correct answer. I wouldn't have dealt fairly with you because I haven't followed my own guidelines and rules I've set down.
And merely saying that, for example, oh, I'm sorry, I forgot, does that compensate for their loss?
No, I wouldn't understand.
What I'm saying is that if you just say that, oh, I'm sorry, it's my fault, I forgot, would they say, okay, if you forgot it, that's fine. I understand. So I've lost out and I accept it. They wouldn't accept that.
No,
They
they
wouldn't take
wouldn't.
your omission as a compensation for their loss.
That's right.
And so they will put you on the spot to remedy that omission. You agree?
I do.
Just because you have a procedure and you didn't follow your own procedure.
That's right.
They will not go anywhere. They will come back to you to fix it yourself. Let's call it do it yourself.
Yourself.
So doing it yourself with a view to correct the problem or the error is called administrative review
Okay.
in simple terms. And who is doing it themselves? In
The
our
person,
conversation, it is
the,
the caseworker, right?
the
Because this is
caseworker.
immigration.
Yes.
Yes, and the caseworker is actually working for the government in the form of the Secretary of State for Home Department. And so we say that if the caseworker gets it wrong, office has gotten it wrong.
Hmm.
Right. Now, so you see that in terms of procedures, where there is a procedure to be followed, we expect the practitioner to follow the procedure. If the practitioner does not follow the procedure, then there is error in the administrative process. And
Okay.
that administrative error has to be reviewed and remedied. And if we are
Hmm.
going to ask for a review for them to know that they got it wrong or they got it right, we call it administrative review.
Okay.
And because this aspect applies to every aspect of our lives, within the immigration spectrum, the caseworker must review the error if the error is pointed out to them. They have to review it to see whether it is indeed an error or not. Because you said this is what you would do, and you end up doing something else, and that has caused the person a loss. Then you have to review it. If the person put a challenge to you to review, so that's administrative review. Simply When a visa is refused, whether outside the UK or inside the UK, or any immigration decision is made
Hmm.
which is consistent with the practice or the procedures or the rules or the law, then the caseworker has gotten it wrong. So, on the basis of illegality, on the basis that it is not consistent, so procedural impropriety, all these things will come in and we say they have made a mistake. Once they've made a mistake by not applying the law or the rules or the timing and everything, they have to fix it. However, you must be sure that you are saying that they've made a mistake and you have evidence that they have made a mistake. So,
What is the nature of the mistake they can make?
So, as we have pointed out, it's to do with the law. You said
Mhm.
that so let's say your rule is that anytime we come on the show, you give a preview to the nuggets based on which the question will be set for answers to be expected. And so,
Mhm.
if you didn't do that, then you have breached your own protocols.
Okay.
So that's one. And for the caseworker, is to do with the immigration rules. For example, paragraph 297 of Appendix FM. If you look at IEIDIF, it says that if the person D says that if the other parent is dead, then the surviving parent is the surviving parent who looks after the child, and so the person automatically will be looking after the child. So you don't have to ask me to prove that I have sole responsibility or not, but suffice to show that I have to add some other information. Again, he says that if you are proving that you are solely responsible, you have to show the evidence. If I'm able to show the evidence, then I don't see why you don't have to give it to me. F says that if there are issues in the life of the child and leaving the child to stay where they are will affect their life, then there is serious and compelling family circumstance that makes the exclusion of the child from the UK undesirable, and so you must grant. If this is the rule and I have met the rule, then you have to give it to me. If you don't give it to me, then you have not applied your own rule properly.
Okay.
That's an example. Another example under Appendix FM, again within the rules, paragraph 6.2 says that a partner is somebody who is married to the person who has been in a relationship akin to marriage for 2 years. And if you are in a relationship, you don't have to show that you are living together. You just have to show that you've been in a relationship. So if I don't have to show that I've been living with my partner and I can show that we've been together for 2 years, and you refuse me to say that there's no evidence of being together for 2 years, then you are wrong, aren't you?
Yeah.
Because the rule says I don't have to be living together for 2 years. I
Hmm.
just have to show that we have been in that
In that
relationship.
relationship for at least 2 years.
Yeah. So what does it mean? It means the caseworker maybe didn't understand the rule and didn't interpret the rule well. And if you are not able to interpret your rule, will you punish me for that?
No, that's your own rule. You are not following.
That's administrative unfairness, right?
Hmm.
So I can seek administrative review on that basis.
Okay. So then, my next question will be, before we go into how to do that, my next question will be, um, do I have the opportunity of doing an administrative review in every situation before I do an appeal, or you make an appeal? That's the right expression.
Right. So appeal is another remedy. So there are three remedies.
Okay.
The first remedy is okay. Well, it's not like one after the other. They are standalone,
Okay.
independent.
Okay.
So you have a remedy to seek administrative review if you are not given other remedies.
Okay.
So if you don't have remedy to appeal, then you must be given remedy for administrative review so that they can review it if it fits. But we'll look at the fits very soon.
Okay.
If you don't have the remedy for admin review, you'll be given remedy for appeal.
Okay.
If you are not giving remedy for admin review and you are not giving remedy for appeal, then there's automatic remedy within constitutional law or public law that If a public officer makes a mistake and there's no opportunity to seek redress, you can go to court for the court to judicially review that decision. And that's called judicial review.
Okay. Okay.
So you see that there are instances where you are told that you can do this as a remedy. You have to apply that. You can't say, oh, I want a better one. They are all good. So if you are told admin review, you go for admin review. You just follow that. If you are told appeal, you follow the appeal. They won't tell you judicial review because the judicial review is automatic if you don't have any
You
other
have those two rights. Okay. Okay.
right.
So then I can say that if I don't have the chance to appeal, I can ask that administrative review opportunity is given me. But if both fail, definitely I have the built-in right in the Constitution that I could go for a judicial review. Correct?
So to an extent, and the
Okay.
extension of it is that it is not like you are asking for it. They will give it to you. They have to give you the remedy option.
Okay.
So, for example, students will be given remedy option of administrative review.
Mm-hmm.
Skilled workers will be given option administrative review. Skilled worker dependents, option of administrative review. Student dependent, option of administrative review. There are others who will be given appeal rights, and therefore you have to look at what my next chance is or step is. Once you are told to do something, that's what you will do. But if you are not told at all, for example, visitor's visa, if you are refused, you don't have admin review, you don't have appeal, no rights, no remedy at all. And that you can go for judicial review because that is the only option.
Okay. Well, we're looking at how to successfully make an administrative review application for a visa refusal. How do we do this? Lawyer Charles Osma from BWF Solicitors has the steps and the various processes to follow. For you, all I ask you to do, pay proper attention. If you have a pen and a notepad, pick it, put it down, and start making notes. Or when we are finished and you have a question, you can come in to ask. The lines will be active 0208 493 7345. Or you can send a text or WhatsApp to 07399 208 468. 07399 208 468. And Lawyer Charles Osma will be gracious enough to answer them for you. And you can also leave them in the comment section down below, both on Facebook and YouTube. Remember, we're live on Facebook and YouTube at BWF Solicitors and BWTV. The community and the law is the program. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And we're back, and we're still live on BWTV, bringing you the community and the law. Resource person and guest this afternoon, I should say, is lawyer Charles Asma from BWF Solicitors. Asma, now I would want us to go to the drawing board, the calculating board, the classroom, and see how we can successfully make such an effort to get that reviewed for us, that refusal decision.
Thank you very much. So, viewers and listeners, what we are going to do is to look at the administrative review procedure or the rule book. We also look at a case study. If I say case study, a decision that was negative, a refusal decision. We look at how we approach the administrative review, and we look at the decision that came, which made us believe that you can successfully seek administrative review. So we're going to go through a case study of a sort, and therefore the conversation will be in line with that particular application and decision. And this will be a skilled worker child application, skilled worker dependent child application under appendix skilled worker. So, as we have already said, visitors visas do not have administrative review rights and they do not have
Okay.
appeal rights. Student visas have administrative review rights. Skilled work visas, administrative review rights. Most other applications, appendix FM applications, UU applications, mostly have appeal rights. And therefore, depending on which one you are granted by the caseworker, you have to follow that. If that doesn't work, then your next option will be whatever is within the rules. So our producer is going to show us the administrative review guide for caseworkers.
Mhm.
When someone brings an admin review, how should they approach it? So, yes, and this is updated 18th of February 2025,
25. That's quite recent.
quite recent. Yes, so if we look at the update, producer, please click on see, or okay, no, leave it. You leave it for now. Scroll down to our bit. So, administrative review. We look at the eligibility.
Mhm.
Eligibility. And Brakuku, you are going to help us with
The
that.
reading, yes, I'll go ahead with that. Um, Eligibility requirements for administrative review. It says specified route requirements for administrative review in relation to applications for entry, clearance, or permission to stay. So we have AR 1.1, which says the decisions eligible for administrative review are those under the following route. Appendix ECAA, that's extension to stay, extension of stay. Appendix student, appendix short term student, that is English language, appendix child student, appendix parent of a child student, appendix graduate, appendix skilled worker, appendix global business mobility routes, appendix T2 minister of religion, appendix representative of an overseas business, appendix UK ancestry, appendix global talent, appendix high potential individual, appendix scale up, appendix startup,
A lot of
innovator.
them. A lot of
There's a
them.
lot of them,
So,
yes.
viewers and listeners, we have pointed you to that appendix. You can refer it later on because time will not permit us to go through all this. So you can see, Bragoku, that anyone who is on this list
Hmm.
often than not will be given administrative review rights.
Okay.
So we call them administrative review rights specified routes. And that's why the case study we are going to have, the example, we will see that this is a child who applied to join the mother in the UK as a skilled worker dependent.
Okay.
Okay, now let's move on to the next one. Go back to, so we've looked at eligibility. Let's move on to the next one. Producer, please take us back. So we've
So
gone through
then
the
we're
eligibility.
looking at AR 1.2, and
Yes,
or we should go to the validity requirements for
let's
administrative
look at
review.
the validity requirement, please.
Okay. So then we have AR 2.1. An application for administrative review must relate to one of the following decisions. That is the eligible decision. It's either A, decision to refuse an application for entry clearance, or B, a decision to refuse an application for permission to enter, or C, a decision to refuse an application for permission to stay, or D, a decision to cancel permission to enter or stay made on the person's arrival in the UK where the result of the cancellation is the person has no permission and where the reason for the cancellation is one, there's been a change of circumstances since permission was granted, which means that permission should be cancelled, or B, or two, so to speak, permission was obtained as a result of false representations by the person or by their failure to disclose material facts. Or then there's another bit of the eligible decisions, which is E, the period of grant or conditions attached to the person's grant of permission to stay. Lawyer.
Okay, thank you. So you see that a visa refusal covering any of the following could attract administrative review rights.
Mm-hmm.
Did you see visitors in there?
No.
That means visit applications refused cannot have admin review rights.
Okay.
Right. Now, if we go to 2.2, if we go to 2.2, we're looking at application for administrative review must relate to the decision. So you cannot seek administrative review about something else, which is not in the refusal decision.
Mm-hmm.
So when you are setting out your grounds, it has to be in line with the refusal. You cannot raise another point, which is not an issue.
Okay. So
Let's
then
move on.
they when they
To,
refuse you, they will give you the reasons for the refusal. And if
yes,
you are challenging that decision, it has to be within the refusal letter or the notice that they have given you.
exactly. And as we saw in our analogy, you say that anytime we come on the show, you give people opportunity to understand the nugget before you
Mhm.
test them on the nugget, right?
That's right.
So if somebody didn't answer the question, somebody didn't pass the question or didn't get it right,
Mhm.
not because you didn't give them the opportunity to understand the nugget, but because they didn't understand the question, can they challenge you on admin review grounds?
Um,
Okay,
it's
let
a
me
bit
put it
tricky
again. Let, let-
because
let me put it again. Let me put it again, Brakoku.
uh-huh.
What they are saying is that they have failed the test. Then
Because I didn't
it turns
explain.
out that you didn't do anything to contribute to that. You gave them the opportunity. They understood the nugget. Whether they understood it or not, it's their matter. But you
Mhm.
went through the nugget with them. So if they didn't pass, then the reason could be something else, right?
Yeah.
Would they challenge you or put you on the spot that it's your fault?
The
No.
ones that followed my regulations and procedures, it can be my fault.
Exactly. And therefore, they cannot say that I didn't pass because maybe my phone wasn't working, I missed that bit or whatever. That is not the issue. The
Mhm.
issue is that they have been refused. And if you are refused, the caseworker will tell you why you are refused. So if the person is saying they didn't pass the test or they didn't answer the question correctly because you didn't give them the opportunity to go through the nugget because you didn't do it, then you can say that it's an error on your part.
Mhm.
So we go through the refusal, and the refusal will be clearer what the reasons are. if the reasons are such that the caseworker appears to have made a mistake, because everything in there you followed and you did it, then it is not your fault. Then we can say there have been an error on their part. So that's the point I'm making, that you cannot raise any issue if the issue is not in the administrative, in the visa refusal decision.
Hmm.
Right. Can
Okay.
we go, producer, producer? So we've
What
touched
is
on we've touched on eligibility, we've touched on um, validity. If you can move down, please. Yeah, yeah. So, all right, let's look at how to consider the application for admin review. So, what this is for the caseworker to know what to do. So, consideration quickly.
okay? So the decision maker conducting the administrative review, that is a reviewer, in this case will be the caseworker, isn't it, Laura?
It will usually go to a different person because you cannot review yourself.
Okay.
Yeah.
Yeah.
So they
So
will give it. So they have a review team.
okay.
It's different from the person who made the decision.
Okay. All right. So then the person will decide whether the eligible decision is incorrect because A, the decision maker of the eligible decision failed to apply or incorrectly applied the relevant immigration rules, or the decision maker of the eligible decision failed to apply or incorrectly applied published guidance. That's AR31. Now, AR32 says the reviewer will consider whether the applicant for administrative review is entitled to entry clearance or permission on the basis of the original application and would not consider whether the applicant is entitled to entry clearance or permission on any other basis. Then AR 3.3 says where evidence which was not before the original decision maker is submitted with the application for administrative review, the reviewer will only consider the evidence where the eligible decision was a decision under Part 9 of these rules to refuse an application on the grounds of false representations or deception, or B, a decision under Part 9 of these rules to cancel entry clearance, permission to enter, or permission to stay on the grounds of false representations or deception, or C, a decision to refuse an application for entry clearance under Part 9 of these rules on the grounds of a previous breach of immigration laws, or D, a decision not to request specified documents under paragraph 245AA of these rules, and or finally a failure to follow the evidential flexibility policy published on gov.uk, that's the government website.
Very good. So leave four, three, four out. Now, so when we are going to challenge the caseworker on the grounds of procedural impropriety, we are
Mhm.
looking at whether there was procedure, and two, whether they followed or not.
Yeah.
So the procedure will be the rules and the guidelines. Immigration rules are clear. And for example, paragraph 297 to do with children, or paragraph 3.1, 3.2 under appendix children, or paragraph 6.2 for partners, and so on and so forth. These are all rules. So if the caseworker failed to apply the rule correctly, then you can pick that up and challenge them on that.
Mhm.
Again, the rules go with guidance, policy guidance. The caseworkers will be told that this is the new guidance and there has been a change, and they are supposed to apply the new guidance. So if they didn't follow their own guidance, then whatever you said you would do, you didn't do. Is that not the case?
Mhm.
So that is also wrong. So when the caseworker fails to apply the rule or fails to apply the immigration guidance, it's opportunity for them to challenge them on the basis that they have done something wrong and that has cost you the refusal. So when we are looking at the visa application decision refusal, we'll be looking at whether the caseworker applied the rule correctly to come to that conclusion. Now, if you go back, it also tells you that If the caseworker is assessing the administrative review application, they should not accept new evidence that was not part of the original application that has
Mm-hmm.
been refused. However, if the caseworker is refused the application or has refused the application on the basis of deception, then the person or the victim can can produce or provide new evidence to support the claim that no, they have not engaged in deception or dishonesty.
Okay.
And the third point is that if the caseworker has failed to apply the evidential flexibility rule or principle, and what is evidential flexibility?
Yeah.
We are all human, and therefore flexibility is allowed. And so the within the rules and the policies, so that will be a policy guidance. It says that when somebody brings an application for consideration, check the evidence. If the evidence is not up to, but it is obvious that they may have it, but they might have forgotten to add it, ask for it. Are you with me?
Mm-hmm.
So that is human approach, isn't it?
Yeah.
Remind them because it's possible that they might have forgotten or it could be oversight. So give them opportunity. We call it hindsight. Go to them and say that you have applied, we need XYZ. Every day we get these things from them. Sometimes we give it to them and they will come back to ask for the same thing. But when they come back to ask for the same thing, I tell the client, you know what? We gave it to them. Let's give it to them again. After all, we need help.
Yeah.
You give it to them. Why did they do that? Why didn't they refuse? Because the rules say that if you don't follow the evidential flexibility principles or the rules, and you are too strict, and you go ahead to refuse because you think they didn't give you what you need, then you are wrong. And so the administrative review will be on the basis that the caseworker failed to apply or follow the evidential flexibility. And do you know why the caseworkers always arrange interview and also come back for evidence? And they will say, you are giving 14 days, you are giving this 10 days, you are giving that, bring this. Do you know why?
No, tell us, please.
It's because under the appendix administrative review, it says that if you fail to apply the evidential flexibility rule to ask for further clarification from the person or the applicant and you refuse, the person can challenge you on that point.
Okay.
Is interview a clarification that the caseworker may be seeking?
Y- yes and no.
Well, I will agree
Clarification
with you.
because
I will
they.
agree with you. I will agree with you on the first one, your
Mhm.
first answer.
Which one? Yes and no.
Yes.
Um, why?
Okay, good, good, good. I like the way it's going. I know I agree with you on your first answer, which is yes. Because you said yes and no. Your first
Mhm.
one was yes. So it is yes because the caseworker is supposed to come to ask for XYZ.
Mhm.
And so if they don't, if they ask, if they invite you to speak to you, that's clarification, isn't it?
Yeah, because there are some questions that you'd be asked.
That is why sometimes they will come to you that, okay, we want you to attend interview.
Mhm. But we are not
Anytime,
often we are often not very comfortable about interviews.
well, but that is also for them to tick the evidential flexibility approach tick box.
Mhm.
Because there are a number of occasions where I challenge the caseworkers to say that the rules say that if you are unclear, ask. But you didn't even invite my client to answer those questions that you were doubting.
Mhm.
So how will you then conclude that you were not satisfied?
Yeah, I get it.
And so the caseworkers who know what they are doing, we invite you to attend interview. So when we are invited to attend interview, they are not being harsh, but they just want to see clarification. And therefore we have to go prepared to respond to that.
So what
Because
what what if they don't ask for interview, but rather they write to you via email or a letter to provide certain documentary evidence? Would that suffice?
that is also a way to show that they have followed the evidential flexibility rule by
Mhm.
seeking clarification by way of further documentation or a missing information or missing evidence.
Okay.
If they don't do that, I will tell them that, hang on, your own policy says that you must do X, Y, Z. When you were in doubt, did you seek clarification?
If they didn't come back to you, then obviously they didn't.
It's even possible that the people who scan the document and all that, because everything is electronic, it's possible that it didn't upload. It's possible that the people who collected at the embassy to upload to scan and upload them didn't do everything.
Mm-hmm.
So you cannot punish me for whatever reason. So you have to come for clarification.
Okay.
And so when we are going for admin review, we have known that one, they didn't apply the rules correctly. Two, they didn't follow the policy correctly. Three, they have accused you of deception without coming for clarification. And three, they have not followed the rule to seek further clarification or further evidence if the evidence is not totally different from what they already have. It could be that it's not clear, the photocopy or the scan wasn't clear. So if you can't see, ask me to give you another one. Don't just say that I can't see and so you don't have it. I have it, just that you can't see it.
Okay.
So those are the points. Now that we know that our client can seek administrative review, how do we approach it?
Yeah.
So, producer, before you move on to the next one, which is the casework document, I want you to please help us with what happens during the administrative review. What happens to the client visa if it is in country, for example? So go to the guidance appendix, administrative review guidance, and scroll down, please. Yeah, effect of admin review.
Okay. So then we go to admin review 4.1. It says where an administrative review is pending in relation to a decision made while the person was in the UK, the applicant for administrative review will not be removed from the UK.
Full stop.
Okay, yeah.
This is
Um,
good news. This is good news, isn't it?
Definitely. So once you've put in something, it stops the clock or the wheel, isn't it?
Yes, and this is the reason. The moment you are challenging the decision, can we say that the decision is not yet over?
It's not over because there's the chance that it could be reversed.
Very good. And so when you have chance for administrative review, consider asserting that right of going for admin review, provided the
Mhm.
chances are high, because that will give you the chance to continue with your life. If you are protected under section 3C, your rights will be protected. And if you are seeking leave to remain in the UK on the basis of any area, as long as decision is not made because there is administrative review in progress, you cannot be removed from the UK either. Right.
Okay.
I wanted to point out. And let's go to the decision, the final part, please.
So that brings us to AR 5.1. And it says the outcome of an administrative review will be one of the following. There are four of them. Administrative review succeeds and the eligible decision is withdrawn and will be reconsidered. Or the administrative review does not succeed and the eligible decision remains in force for all the reasons given in that decision. Or three, the administrative review does not succeed and the eligible decision remains in force, but one or more of the reasons given for that decision are withdrawn. Then four, the administrative review does not succeed and the eligible decision remains in force, but with different or additional reasons to those given for that decision. Um,
this
obviously, I,
is
I
what
have my
this is
issues with that. You know the issue. I know you go through that, but let me bring this one. When I was reading, it was just going through my mind that you are asking me to ask for the review based on the decisions you have put in the letter. Okay. Now
yes.
C and D are saying that you will not rescind the decision, but one or more reasons of that were in there would be withdrawn. That's fine. But this says that there could be additional reasons given for that decision that was given. But that was also not in there. So why are they bringing in something new when I can bring in something new?
Right, I agree. But okay, let me touch up on the first one. The first one is the example we are going to have very soon, where
Okay.
the admin review challenge succeeded and end of matter. We are waiting for the visa to be issued so that the child can join the mother.
Mm-hmm.
B is where it doesn't succeed. They maintain it and they say, no, we are not changing our mind. It is what it is. But C is an example of C is where the person has been refused under paragraph 9.7.1 and 2. One is deception with discretion, and two is deception on mandatory grounds. So when caseworker is going to refuse it on the basis of false representation or false evidence, they have two options: compulsory or not compulsory. Compulsory is where mandatorily they have to refuse you, and that's 7.2, that's 9.7.2. Then caseworker can also be flexible and say that, you know what, I'm going to refuse you because of false evidence or false information.
Mm-hmm.
However, I'm not going to ban you.
Okay.
So somebody can be refused and banned under paragraph 9.7.2, which comes with a ban 10 years. And paragraph 9.7.2, when you get it, and for refusal, you get punishment, which is the 10 years. So anytime you come for visa, you make a visa application, it will be automatically refused under 9.8.1.2.3 going. So there are instances where clients will come with their decision. This client is an innocent victim of the circumstance. Because yes, the bank statement is fake, but the bank statement is not even his bank statement. The uncle or the brother or the sister helping gave the bank statement to them to support the application. And
Mm-hmm.
it turns out that that bank statement is fake. Whose fault? Is it the sister's fault, the bank's fault, or this applicant's fault? Whose fault?
Well, the bank applicant may have given the false information. So this applicant, visa applicant, may be innocent.
Thank you. And you have passed your Law 105 module. You have
Thank you.
passed. Good. So certificate will be posted to you. So
Thank
what we
you.
are saying is that if the person cannot be construed to have deliberately and directly committed the offense, the person may be innocent, and therefore he can only be or she can only be a victim of the circumstance, isn't it?
Yeah.
So will you punish victims who are overly innocent? That may not be fair. And so when the person has been punished because of the deception or the fake document, they have been banned for 10 years. We put in a challenge to say that, yes, you are right to refuse the application because the information is not true. However, the rules say that you have two options: be soft or be hard. You can only be hard if the person has committed the deception deliberately.
Okay.
That means the person is aware. There's mental application of the whole process. So if the person did not commit the offense because they are innocent, that means they cannot be seen to have deliberately committed the offense. So much as there is offense, which is deception, false evidence, the mens rea is not there, and therefore there's no intention. And the caseworker rule says that there's deception, intentional deception. So if the person is innocent, can they be intentionally committing the offense?
When you're innocent, it has to be proven otherwise. Other than that, then you haven't done anything wrong.
So if the person is innocent because they are not aware of what was happening, then they
Mhm.
cannot be intentionally dishonest.
Dishonest,
So
yeah.
if you are not intentionally dishonest, you'll be refused under 9.7.1 discretionary, but cannot extend to a ban. And so if a client has been banned because of fake document, I will put in a challenge, of course, with the client instruction and understanding that these are the chances. I will challenge that, look, yes, I agree that you will refuse my client, but I disagree that you ban them for 10 years because they are innocent. And I
Innocent,
will
yeah.
cite the law, I will cite the rules, and I will cite the procedure, especially where you didn't even invite them to attend interview, especially where you didn't even invite them to come in under minded to refuse protocols. And the rules say that if you are not sure, ask for further information to prove otherwise. He didn't do all that, and so fix it. So when they come back, they will make a decision under C. They will maintain the decision, but they will change the reason or the grounds from 9.7.2, downgrade it to 9.7.1. 9.7.1, you can always make an application again in future, but 9.7.2, you can't for 10 years. So even though I didn't win the visa for my client on this occasion, I have helped my client to be able to apply tomorrow because there's no more ban. Are you with me?
Yeah.
Yeah. So
So
those
you
are
you
the
you have a you more or less have softened the blow for your clients that
that is C.
instead of being banned outright, there's another opportunity to make another application.
Good. That is C. Decision under C. But decision under D is where, after everything and after the challenge, they even discovered that I was aware of the deception. And so they have upgraded the decision from 9.7.1 to 9.7.2 with a ban. And that's D.
Oh, okay. All right. Well, then now it's clearer and I understand. Now, listen, folks, the situation here is when a refusal is made, it is not the end of the story. It's not the end of the world. You could have options. What we have discussed today, it has spelled out the type of applications and situations where you'll be giving the administrative review right. There are situations where you'll be giving the right of appeal. But if both of these are not available to you, you could go for judicial review. That's what lawyer said. Now, today we have concentrated on administrative review when your visa is refused and it's told us where it's done, why it's done, who does that. And when you go for the administrative review, the review team, somebody or the reviewer will be selected apart from the person that refused you in the original one. And then the reasons given in there will be considered, and four situations could happen. Either it will be granted and you go scot free and you wait for your visa. Um, Other situations could happen. But there were two that I had my attention on. The decisions, either one, some of them will be taken off, or others would be added in there. And Laura explained the situation. You have questions, you have concerns, you have any queries, you can send a text to 07399 208468, or you can come on the line 0208 493 7345, or leave your questions and comments in the comment section below on Facebook and YouTube. BWF Solicitors and BWTV. We're taking a quick break for Laura to have just a grab of something to cool his throat down. And when we come back, we'll pick up one or two questions, then invite you to come in as well. The community and the law is brought to you by BWF Solicitors. Remember, BWF Solicitors is on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. N15 4NP. If you're coming by public transport and you go through the underground, you take the Victoria line and alight at Seven Sisters, use exit number 2. It will bring you to the frontage of the Anna House. Walk in there, fourth floor. They are there Monday to Friday between 9:30 in the morning and 6 p.m. 0208 493 7340. They have an office in Ghana. So those of you in Ghana who want to engage their services, you can call them on 055 589 5959, 055 589 5959, or worldwide in emergency situations or whatever situation there is that you find yourself and you need to speak to lawyers, especially BWF solicitors, call 0044 7712 761884, 077 1884. Or you want to talk to Lawyer Charles Asma directly, I will give you his line of hope: 07947 636037, 07947 636037. We have been discussing how to successfully make an administrative review application for a visa refusal. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
We're welcome back, and we're live on BWTV, brought to you by BWF Solicitors. Lawyer Charles Osma has been taking us to how to successfully make an administrative review application for a visa refusal. He mentioned earlier on that he was going to give us a live example as to what was done, what refusal it was, the grounds for challenge, and then we can move on from that. So let's see the example you wanted to give us.
Thank you very much. Producer, can you please share the decision with us? Thank you very much. The decision has been redacted to comply with the GDPR rules. This is Sobrakuku, the date and the reasons.
Okay, so this was dated the 13th of May 2024, and it says you applied for entry clearance as skilled worker child health and care on 23rd of April 2024. I'm writing to tell you that your application is refused. What this means for you, you can apply for an administrative review of this decision. Instructions on how to apply can be found under the next steps section. The reasons for this are set out in the next section. So the entry clearance officer writes and signs. The reasons are here. Your application has been refused for the following reasons. You applied for entry clearance as a skilled worker child health and care under Appendix skilled worker of the immigration rules, your application has been refused because you do not meet SW 32A.1 subsection A with reference to paragraph CHI 3.2 of Appendix Children and CHI 3.2. CHI 3.2 says the applicant's parents must each be either applying at the same time as the applicant or have permission to be in the UK other than as a visitor, unless A, the parent applying for or with entry clearance or permission to stay is the sole surviving parent or has sole responsibility for the child's upbringing, or B, the parents who does not have permission, one, is a British citizen or a person, can we pull it up a bit? A person who has a right to enter or stay in the UK without restriction, and two, lives or intends to live in the UK. Or C, the decision maker is satisfied that there are serious and compelling reasons to grant the applicant entry clearance or permission to stay with the parent who is applying for or has entry clearance or permission who is covered by CHI 3.2b. You have applied to join your mother, who is a skilled worker health and care partner. However, I'm not satisfied that your mother has sole custody of you or no, that there are compelling circumstances to grant you entry clearance. Whilst I acknowledge that your biological parents are no longer together, your father does not have permission to enter the UK. As part of your visa application, you submitted these documents: your passport, birth certificate, DNA test, mother's passport, family photographs, TB certificate, consent letter from your father and your stepfather, mother's stamped visa, vignette, and passport, your mother and stepfather's marriage certificate, the stepfather's BRP card, stamped visa, vignette, and certificate of sponsorship details. It goes on. Tenancy agreement, pay slip and bank statements, school reports and receipts, child study report, enrollment letter from your church regarding your attendance, transaction receipts from your mother to your school, a medical report document regarding your grandmother dated the 16th of April 2024, a letter confirming your hospital registration. It goes on to say that the Home Office wrote to you using the email address provided with your visa application on the 7th of May 2024 to request more information in line with Section 55 of the Border Citizenship and Immigration Act. Amongst other evidence, we also requested the following. Please provide any further evidence, information, or documents you would like to be considered in line with points A, B, or C. The Home Office received a response on the 9th of May 2024, and you submitted the following: your child health card, further family photographs, WhatsApp messages between your mother and school teachers, call logs between yourself and your mother, an affidavit from your mother regarding your late registered birth certificate, and your 0 to 12-month birth certificate. Then the decision maker said, I have considered all the documents you have provided in support of this application, and in particular, the absence of any official court documentation that awards your mother with sole responsibility of your care and upbringing. And because this has not been provided, I am unable to establish what involvement your father has in your life, and I'm not satisfied that your mother is solely responsible for you. I've acknowledged all the letters and affidavits and report cards you have provided. However, whilst letters, affidavits, and report documents can be a source of information, they are not considered legal documentation with regards to proof of sole responsibility in the UK. Therefore, you have not provided any official documentation that leads me to believe that your mother has sole responsibility. Taking into account, the bank statements, receipts, and other fees, the financial responsibility does not necessarily constitute a genuine transfer of sole parental responsibility. I am not satisfied that these documents alone can be accepted as evidence to demonstrate that a genuine transfer of sole parental responsibility has taken place. I've noted that you have stated on your visa application form that your father has supposedly traveled to a neighboring country. However, there has been no proof of this travel provided, and I cannot be satisfied that you are currently residing in a different country to your father. Therefore, I am not satisfied. I also note that you have provided a medical letter in your documents regarding your grandmother's declining health. Whilst I do not dispute this, I do note that this document is dated the 16th of April 2024, which is a week before you submitted your visa application. There has been no further evidence submitted to show your grandmother's declining health during previous months. This therefore leads me to believe that the medical letter was provided for the purpose of facilitating your visa. You did not provide any evidence in support of your application, which may have outlined serious or compelling reasons why you should be granted entry clearance without your father. Applicants should provide all information and evidence on which they rely to support the application as part of the application process. The burden of proof is on the applicant to demonstrate that they meet the eligibility requirements of the immigration rules. In this instance, I am not satisfied that you have adequately discharged this evidential burden. I therefore refuse your application under SW 32A 1A with reference to Appendix Children. Now, obviously, when you receive a letter like this, you will panic.
Of course, ordinarily, any person will say, "Oh my God, this is the end of it," because I gave everything I need to give. Look at the list of documents. Everything, more than even necessary. The person is refused because they say the person does not meet sole responsibility. So what did we do? I told the client, I know what, don't worry, this is not the end of it. The caseworker has misunderstood their own rules and procedures. Let's go and challenge it. And with the instruction of the client, we put in administrative review challenge on the basis that we disagree with the findings. So we have to prepare grounds. So first, identify the issues. And the issue is that sole responsibility is not made out. So we have to go and tell them that sole responsibility is made out, but they misunderstood the meaning of sole responsibility.
Mhm.
So we put in grounds. And producer, just show us the grounds briefly.
Okay.
So yeah, properly redacted. Thank you. So Brad, we could just sift through and just few bits. So this is the background. This is the
Okay. So
background.
the applicant being a 7-year-old girl in full-time education. Now, you stated that the
Um, okay. So what's going to happen? So producer, move straight to the rules where we apply the law. Straight to the rules. Yeah, the law. All right. So we had to quote the law to
okay.
point them that no, they have made a mistake. We have to explain what sole responsibility itself is and how the law interprets sole responsibility to be, especially the case of the various cases that support the point for sole responsibility,
Mm-hmm.
such as TDMN and all that. If you go down, please, just a bit down, I want to be sure that there is no name anywhere. So when I see a name, I will just ask you to move quickly. Okay, so okay, yeah, all right. So there's no name here. So here, if you look at 16, I made a point that furthermore, the best interest of the child must also be taken into account. The statutory guidance. So I quoted every child matters agenda for UK. And I
Mm-hmm.
referred to paragraph 2.34 of the guidance, which state that statutory duty under section 55 is upon the caseworker to make sure that the child is not disadvantaged in any way. Then we move on to 18. Go to 18, please. So this is clean or clear. Brakeku 18, in the light of the
So, in
above.
the light of the above, we wish to emphasize that the love and affection that a mother will provide to her child is not the same as that which is given by another family member. Therefore, even if her grandmother was active enough to perform the care duties of the applicant, she cannot be compared to their mother's love, as that's what we want to mean. Therefore, to refuse the application would mean that the emotional bond and attachment between the sponsor and the applicant will be severed, as it is difficult for an emotional bond between a mother and a child to be provided by way of telephone communication perpetually. We know that recent administrative review decisions in relation to sole responsibility does not reflect the evidence of the law. We therefore put to your notice that were this case not to be considered properly in light of the evidence and the law, will be going for judicial review against your decision. You threatened them, didn't you?
All right. So this was our challenge.
Mhm.
So you see that you have to identify the issue that you are not happy about, and the issue is sole responsibility. And we
Mhm.
realized that the caseworker misunderstood sole responsibility to mean court document like we have in the UK, child arrangement order.
Yeah.
See, so they got it wrong. What happens in UK is different from what happens in other parts of the world. So we went in, and this is the decision. Producer, what's the decision finally? Right. So Braco could take us. This came when?
20th of February 2025, which is just a few days away.
So
Dear,
pause for me, Braco. Somebody asked a question: how long would administrative review decision take? We started the case in 2024, and the decision came in 2025 February, and therefore it can take a year, it can take 6 months, even though they usually say 28 days, it goes beyond that. That is for people who want to know how long. But yeah, please go ahead.
and I think in some it says your application for administrative review has succeeded. And it quotes the date that you sought to apply for administrative review of the decision dated in the letter. And they said, we have carefully considered the points that you raised in the application for administrative review. We have overturned the decision to refuse your application for entry clearance. The decision of May 13, 2024 is withdrawn. Your application of 23rd April 2024 has been sent back to the original case working team to reconsider. They will make a new decision on your application and tell you the outcome. If your application is refused, you'll be entitled to apply for a fresh administrative review of the decision. If you pay the fee for your application for administrative review, your payment will be funded in full. We apologize for the errors made in the original consideration of your application.
Right. So that is how they will couch it to say that there are four decision options. The application to challenge is succeeded. However, they will review it, and we are expecting that a letter will come through by email to say that the child should um, send a passport to the biometric center so that the visa can be issued, so that the child can join the mother in due course. So, this is how to successfully make an administrative review application for a visa refusal in the context of child dependent applicant under appendix skilled worker. There are a whole range of visa refusals, but for this conversation, we related it to child dependent applicant under skilled worker provisions.
As for this one, I dare say that there wouldn't be too many questions because it's very comprehensive, very clear. But in any case, if you have any questions or comments, please do not hesitate to send it over to us via text 0739920848, or you can call in now quickly on 0208 493 7345. A few of them we can quickly pick up and get Lawyer to explain. But remember, my quiz scenario, Lawyer has used my dealings on the program as an example. So today I will give you the benefit of looking at the nugget and the scenario, and then you give me an answer. I've done that already, but I'll repeat that for you. Now let's see what we have on the I submitted my naturalization application in December 2024. As part of good character requirement, would they use previous applications made about 17 years ago using a different name against me? On the application form, I answered yes and gave them the full name and the date the application was made. This was sent via text. Via.
Right. I think this person is on the application form. I answered yes and gave the full name and the date the application was. Well, even if it's a case that you entered illegally, this will not affect you because the law is not taking retrospective effect. It's
Mm-hmm.
starting from 10th of February 2025. And so this will not apply to you. But your question is about change of name, isn't it? It says I changed my name or something.
Mm-hmm.
Yeah. My brother, I don't think you have to be so concerned about the new policy because your application was before, and even that, it appears that your issue is different from illegal entry or legal entry.
Okay. Another one here via text is saying that um, are there other agencies or companies employment or employed? I think that's what he wanted me by the Home Office to carry out immigration rates or checks. Circle and G4S. They do they work for the Home Office? Do they carry out immigration rates or check? Circle was spotted outside London at a local shopping center with a van that looks like police van with police van but was labeled Circle with tiny windows. Staff got out of van and instructed by a leader to enter some specific shops, dressed in blue uniforms with IDs hanging around their necks. Could they be working for the Home Office?
Okay, our friend is a public rights advocate, so he's good. He's not asking the question for himself. He's asking
Mm-hmm.
for many people who may be uh, in trouble because of one thing or the other. But I don't know whether Seiko works for the Home Department. However, I think if Seiko is under instruction to, as it were, check if people have papers or they don't or whatever, whatever. They will have immigration officers with them in that van.
Mm.
So, my brother, what I would say is that if anybody um, is picked up by Seco, the person can challenge if it turns out that Seco does not work for the Home Office. So let's wait for anybody to come with a challenge about Seco, then we'll assist the people on that basis.
Well, keep them coming through 0739920848. That's for text. And you can also leave your comments in the comment section down below. Please, how can one know the arrival date if they can't remember the arrival date and has adopted a new uh, ID, I guess? Would it affect the indefinite leave to remain in British citizenship? Regina is asking, Laura.
Right. Then what they can do is apply for subject access to
Mm-hmm.
request their document or their record from the Home Office or the government custody. Once they receive the subject access request report, they will have everything from the time they enter the UK. So that is an option to know what they have about you. The next thing is um, would it affect their indefinite leave and citizenship? Indefinite leave is not an issue. The key thing is the citizenship. So if you enter the UK with visa, you know, even if you don't remember the date.
Mm-hmm.
But if you don't know how you entered, which I'm sure the person is worried about, then check your record by asking for the information. And if the information comes and it's not there, then it will be difficult. To be fair, once you put in the citizenship application, if they think that you don't qualify, they will only refuse it. But you still have your indefinite anyway. But you want to make sure that you do it right with high chances of success. So get your request, make a request for your record, and make sure that you request the service of a good immigration lawyer to handle your case for you because the law says will not usually be granted. That means it's also possible that you'll be granted based on how you go about the application.
Right. Let's see. Let's pick up. Is there any question here? Nana 24 has one. My administrative review was submitted 2020 in 2022 in September, and yet no decision. Well, it could take that long, I guess. Laura.
Yes, so what a person can do is to make a follow up. You can send a pre action protocol to say that 2022 to 2025 is a long wait. and you expect them to expedite the decision or at least communicate with you as to the progress of the decision. If you haven't heard anything since 2022, then that is not good enough. So you can complain about it. You can send them a pap and expect they will write to you to say that they are considering, or they will send it to the right team to look at it with a view to finishing your case or deciding the admin request.
You're still live with us on BWTV, and the program is the community and the law. Earlier on, I gave you the nugget, and this was it. Do you know that if you enter the UK without permission, you may not qualify for British citizenship? The law states that a person who is not a British citizen may not enter the UK unless given leave to do so. The new case worker guidance for British nationality now says that from the 10th of February 2025, those who entered the UK illegally would not usually qualify for British citizenship. This quoted from the good character requirement dated the 13th of February 2025. Then I asked you this question. Kwesimin Tim came to the UK through Dover without a visa. He says he traveled by car and was not asked any question by the immigration officers. Kwesi acquires indefinite leave to remain in 2023 after 20 years. He has heard that because of a new law, he cannot apply for British nationality, although his wife and 3 children are all British citizens. Explain to Kwesi whether he is likely to face any legal challenges, and your answer could be one of these three. No, he will not qualify for British citizenship because he entered the UK illegally. He will qualify because he got his indefinite leave before the new law. Or you could tell him that he will not qualify because he needed indefinite leave for 5 years. What's your answer? Think about it. In a moment, I'll come back and take it. Yes, we're back. And what are your answers? Let's see what you have given me. Would it be no, he will not qualify for British citizenship because he entered the UK illegally? Would it be that he will qualify because he's got his indefinite leave before the new law? Or he will not qualify because he needed indefinite leave for 5 years? William Afrani says it's number two. He will qualify because he got his indefinite leave before the new law. Citizen Kojo says number 1A, mean number one, I guess. No, he will not qualify for British citizenship because he entered the UK illegally. Charles thinks it's number one as well. Thank you, Charles. Next one, we still have Charles's bit on there. Thomas, as Samoa says, is number two. Abner Tivo says number one. Nanechi A because there may be exception. Okay, which is number one. Okay. Next we have Fatmata Bangura. Fatmata says is number one. No, he will not qualify for British citizenship because he entered the UK illegally. And then I think for the sake of time, I'll take just about a couple. Stephen Amankwa says is number three. He will not qualify because he needed indefinite leave for 5 years. Zola says number two, he will qualify because he got his indefinite leave before the new. Ken Sterling thinks is number one. Lawyer, what do you think?
Right. So straight to the point. We are aware that from 13th of February, 10th of February 2025, the government has said that any application from that date for British citizenship, they will check how you entered the UK. If
Mm-hmm.
it turns out that you did not enter the UK legally or legitimately, then your application will be refused. It doesn't matter how long you've been in the UK for. So we checked that Kwesi entered the UK through Dover by car. He wasn't cleared, and therefore we conclude that he didn't enter legitimately, so illegal entry. Will his citizenship application hold? No. According to the new policy, he will not qualify for citizenship. One.
Yes, number one, but I can say that he could have indefinite leave to remain, and that will not be taken away from him, I guess, as the law stands now.
Yeah, so it's not about his indefinite, it's about his naturalization because he wants to become a British citizen.
Okay.
So the law only touches nationality or naturalization, not settled status or indefinite status.
Okay, so the explanation, as we can find on the screen, any person applying for citizenship from the 10th of February 2025 who previously entered the UK illegally will normally be refused, regardless of the time that has passed since the illegal entry took place. And this is from the good character guidance that has been introduced in February 2025. Well, let's see. We have been having a very interesting, nice, methodical discussion as to how to successfully make an administrative review for a refused visa application. Kojo says, can make a new application. Why wait for administrative? Anyway, that's not for me to answer. I won't tell you. But Laura will give us a summary of what we have discussed this afternoon.
Thank you very much, viewers and listeners. So this afternoon, we gave assurance that when a visa is refused, it is not the end of the matter. You have to check whether the refusal reasons make sense and they are within the law, within the rules, within the policies. If it turns out that they are not consistent with the policy guidance or the rules or the laws, then you can say that the caseworker did not follow the rules. If that is the case, you can apply for administrative review. In some instances, you'll be given options. One, go for administrative review, so the caseworker will tell you, or appeal, the caseworker will tell you. If your application does not qualify for appeal, you'll be told administrative review. If you are not told administrative review or appeal, then it means you don't qualify for anything. If you don't qualify for anything, because it's a public body decision or a decision made by a public body, the Home Office, you can go for judicial review. That's the starting point. The next point is that for administrative review, make sure that you look at the refusal decision. From the decision, you know what they said and what you disagree. You prepare your argument to answer or rebut those points. And once you have rebutted or you have challenged all those points raised by the caseworker, you wait for a decision to come. Application will be, of course, the administrative review is an application online, so you pay about £80. If it's EU, it's usually free. You then submit online and send your grounds and evidence. You don't have to provide new evidence from the ones you have already sent to them during the application stage. It's only when the caseworker is asking that or is saying that you have been deceptive or dishonest and so you've been refused. That's when you can have new evidence to rebut that presumption of dishonesty. Once the application goes, you wait for a decision. How long? Before the law says or the rules say 28. Now can take 6 months, 1 year, or even more. If you think it's taking too long, you can write to them to complain about the delay. It's your right. Once the decision is made, it's either that you will succeed and the refusal will be reconsidered, or you will not succeed and the refusal will be maintained, or you will not succeed and the refusal reasons can be amended to make it even less punitive, or you will not succeed and the refusal reasons will be amended to make it even more punitive. Either way, they will tell you the new decision and why they have concluded as such. For any help, any assistance, any clarification, you know where to go. Thank you for your time. Shalom.
You know where to go, and I will give you the direction. Fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. Call them on 0208 493 7340. In the Ghana office, you can reach them on the telephone number 055 589 5959. In emergency situations, 077 127 61884. Visit them on their website or go to their website, get information from there, leave your comments and your reviews there. bwfsolicitors.com, social media platforms, BWF Solicitors. It's been an interesting discussion. I want to say, let us all give thanks to the Almighty God for giving us life and the opportunity. And then again to our big brother, Charles Asma, for spending time to give us a good insight as to how to do a judicial review application. And then to
Administrative
you
review.
out there, I am so grateful that you stayed the whole 2 hours with it. And I'm very, very sure that same time next week, we'll be having another time with you. And you'll be inviting other people to come join us. But if you missed any part of the program, the link will be there on our platforms, BWF Solicitors on Facebook, BWF Solicitors on YouTube. Then please share the link and get people to benefit from that as well. I want to say thank you to my producer, Professor Ade, to Sheila Ankra, and Padma Dodu for doing the admin and the aesthetics work, and to BWF Solicitors family for giving the support and the research as well. My name is Ureku Frimpon. Good evening.